Yes.
Uh, I, I'm sorry. I'm sorry. Can you hear now me?
Yes, I understand. It's perfect.
Okay. Thank you, Philip. Good morning to everybody. Welcome to be here with us. This is the second lesson of the mini course in social collective European law of Professor Philippe Dosmon. I thank him again for his presence with us during these days. I let him immediately the floor. Please pose to him any question you need because it's a very good thing to have him with us today and the next days. I let him the floor and please again do not hesitate to pose him any kind of a question you need. Thank you again, and the floor is yours, Philip. Please.
Thank you, Alberto. So, second, part of this mini course, and we will engage in something what is called the social dialogue. I don't like the word social dialogue. It's not something which is used when you talk about national collective bargaining. The notion we use is collective bargaining. And the word social dialogue was, of course, used to cover any kind of exchange, okay, between both sides, management and labor, amounting or to genuine collective agreements or amounting to opinions communicated to the European Commission. So it's a bit a blurry notion. Another word which pops up from time to time is, of course, the notion of social partner. Social partner is being used not in the English language version of the treaty. There you can find management and labor, but it is used in most of the other language version, and it's also a word which is not often used in national collective labor law because it's a little bit ideological. Management and labor do not always see each other as partners because in English, a partner is a person with whom you can dance or with whom you can make love. But I mean, this is not what is at stake in a process of collective bargaining. Now, what I try to do is to start with a kind of a human rights approach. I am looking like a modern Diogenes to the recognition of the principle of collective bargaining. This is in civilized states and in civilized international orders a fundamental right. We want to know whether something has been recognized which looks like a right to collective bargaining in the EU legal order. And then I will engage in a more comparative way in what collective bargaining usually means in a national legal order. So we can compare it with this creature called the social dialogue in the EU legal order. And then I will dig into the more technicalities, okay, the technicalities of the provisions in the Treaty on the Functioning of the European Union. Okay, that is more or less on the menu. Now, first things first, is there a kind of a recognition in the legal order of the European Union of this right to collective bargaining, which in fact has been recognized by the European Court of Strasbourg, the European Court of Human Rights, in the famous Demir and Baykara case, which is recognized in Article 6 of the European Social Charter, which is obviously recognized by the ILO. And we should say that it took some time before the court recognized such a general principle of EU law, although there were some judgments which were very positive in a way and very consistent, perhaps, with some notions, some aspects, some dimensions of the right to collective bargaining, but the court did not take the effort or the opportunity to refer to the right to collective bargaining. And the first case is the so-called Albany case. The Albany case is a case about collective agreements which were concluded in the Netherlands and which were declared generally, universally binding, erga omnes, as we say in Latin. So this case is about negative integration. It is about EU economic law, and to be very clear, competition law, which is being mobilized by employers to outlaw, if you want, to outlaw a piece of Dutch social protection, a system, a statutory system framework for collective bargaining. What happened was that in the sector, in the branch of the textile, a collective agreement was concluded, which provided for a complementary social security scheme, complementary to what the law, the statutory law, would provide. And this meant, in concreto, that all the employers in the textile sector had to pay some money, some premium to a fund, which would then distribute with this money benefits to workers in the textile sector. So far, so good. But of course, one of the non-organized employers, not affiliated to the signatory employer organization, objected to this practice, saying that this was a way to kill competition in the field of these complementary insurance schemes, because the social partners, if you want to use that expression, had created a kind of monopoly on the basis of that collective agreement, favoring one and not another insurance company. It's not a stupid argument, it's an intelligent argument, but it would, of course, create a big tension between competition law on the one hand and an idea of collective autonomy. Which, however, was not yet recognized at EU level, or at least by the European Union. Now, what the court did was something very interesting. The court said, yes, we do have competition rules, definitely. They are in the treaty, they are constitutional. But we also have this idea in the social policy title that the Commission should encourage, should promote the social dialogue at EU level. Technically speaking, it's not a convincing argument, because this is not about the social dialogue at EU level. This is about the social dialogue in the Netherlands. But of course, the court wanted to extrapolate and wanted to say there is this respect for the social dialogue, for collective bargaining, and therefore we, the court, we state that collective agreements do not fall within the scope of application of these provisions on competition. So there was no clash. You see, technically, there was no clash. The competition rules did not apply to the collective agreements. A lot of authors have written that, therefore, there is a kind of an immunity of collective agreements from competition rules. You can phrase it like that, but the idea of immunity, of course, technically means that as a matter of principle, a phenomena falls under the rule first time, and that you then, in a way, protect it or make it immune. And here the court much more radically said, okay, collective agreements do not fall within the ambit of these competition rules. Now, it's interesting to wonder whether this amounts to a recognition of the freedom of collective bargaining, the right to collective bargaining, and the answer is no. The court did not recognize the right to collective bargaining. There was no need to do that. And in fact, in an opinion, what is called in French a conclusion of Advocate General Jacobs, in this case, Jacobs said that there was not really sufficient convergence in the law of the member state to assume that there was such a right to collective bargaining, a right to collective autonomy as such, but that one could deduce it from a recognition of the principle of individual autonomy. So he sees collective autonomy as a kind of a consequence of individual autonomy. Quite frankly, I couldn't agree less, because individual autonomy and collective autonomy is something entirely different. Individual autonomy is about individuals signing contracts, and you cannot reduce the collective agreements as something which is concluded between individuals through a representative. That's really extremely essential. This was already stated by Zinsheimer, okay, at the beginning of the 20th century. So Jacobs has completely misunderstood distinction between individual and collective autonomy. But all in all, a nice judgment which saved collective agreements, but without recognizing, obviously, a principle of collective bargaining. And then there was a case with the name which is very difficult to pronounce, the UEAP case. UEAP is an abbreviation, comes from Nom des entreprises artisanales et des petites et moyennes entreprises, so an employers association organizing, okay, small, medium enterprises, which challenged a directive, which started a procedure to annul a directive which had been adopted. Okay, now this was a special directive which implements a pre-existing collective agreement. Okay, we will talk about that later this morning. And the reason why UEAP thought that this directive was null and void was that it was in a way implementing a collective agreement which was concluded by organizations which were not sufficiently representative, at least on the management side, on the side of the employers. Why? Well, because UEAPME was not among the signatory parties, and UEAPME thought that the voice, okay, of small and medium enterprises was not sufficiently heard. And it objected against also the fact that it was not invited, okay, at the bargaining table that it was excluded. And here the court profits from the occasion to highlight that at the bargaining table, you're invited or you're not invited, and there is absolute freedom. So the criterion is very subjective. It's mutual recognition, like on Facebook. I want to be your friend. Okay, you are my friend, and that's it. You cannot start a lawsuit because I refuse to be your friend on Facebook. And then is, of course, stressing the voluntary dimension of collective bargaining, which is perfectly consistent with the case law of the ILO, but there was no reference, okay, to that case law. There was no reference to the freedom of collective bargaining. In the end, you can say that there is a general principle of EU law because since the Charter of Fundamental Rights of the European Union, which entered into force in 2009, we have this Article 28, which recognizes the right to collective bargaining. And more or less simultaneously, in one case, which is an infraction procedure, Commission versus Germany, the court also recognized formally that there was a principle, okay, of collective bargaining. So you can say that, okay, there is a principle of collective bargaining, right to collective bargaining. It's a fundamental right. It is a general principle, okay, of EU law. But then we go back to the classical diritto sindacale. We go back to the old story and history of collective agreements, because I want to know whether that species, which we call framework agreements in EU law, is a similar beast than the classical creature, which we call a collective agreement, which we call even a collective labor agreement. Now, a famous Italian lawyer, of whom I always forget the name, has once made this wonderful image of a collective agreement as something hybrid, okay, because it has the body of a contract. If you look to it from a formal point of view, it looks like a contract, this beast, but it has the aim, the animus of a regulation. So in Belgium, we always say that a contract, a collective agreement, has two natures. It is a contract and it is a regulation. And you already see that this is something very complicated for lawyers, because lawyers are well trained here on the continent on the basis that there is this dichotomy, this bifurcation between public law on the one hand and private law on the other hand. And by this phenomena, okay, which has the body of a contract, which is something private, and the anima, the soul of a regulation is therefore very difficult to grasp. Now, what is at stake here is a trade-off. We should know that. It's a trade-off between management and labor, who want different things, entirely different things, but on the crossroads of these very different objectives, an agreement can be concluded. Obviously, what trade unions, what employees want is decent working conditions, especially, I would say, decent wages, a fair and a just remuneration. And they also want to avoid a kind of social competition between workers on the basis of their salary. This is not what the employers want. They would be very happy to pay as less wages as possible from an economic point of view, but they do want to economize on transaction costs if they can make one agreement which sets for hundreds, even thousands of workers, if it is at the level of a branch, of a sector, the wages. This is less time consuming, okay, than having to negotiate on an individual basis with all these individual workers. And on top of that, from a sociological perspective, okay, these employers hope that by concluding such an agreement, there will be a bit more social peace, there will be a lower risk of conflictuality, recourse to strikes, etc. It does not mean at all that from a legal perspective, the conclusion of a collective agreement generates a prohibition to strike. I am not suggesting that. That can be very, very different from one legal order to another. And what we also need to understand from this historical introduction to the phenomena of collective agreements at national level is that collective agreements have always preceded the elaboration and the adoption of a statutory legal framework. Even in a wonderful country like Italy, was still waiting for a statutory legal framework ensuring a efficacia erga omnes. But this has never prevented collective agreements from being concluded. So we must be very modest as lawyers. There is no direct relation between the legal framework, which tries to nudge social partners to conclude agreements, and the actual conclusion of agreements. Just as there is no direct relation between the recognition of a right to strike and the occurrence of strikes. Strikes have occurred in a completely illegal way, in fact, in the past. Now, why I'm telling you this? I'm telling you this because I now want to have a look to this other phenomena, which is called the social dialogue, to see whether it can be compared to collective agreements as we know them from the past. Now, we should, of course, first remember that the European Union and that the European economic community has been preceded by other communities focused on coals, focused on atomic energy, which already had their sectoral committees in the field of coal, in the field of steel, atomic energy, and so on. And these committees were committees where employers' associations of the sector were, in fact, represented. So employers' associations, trade unions, and which had to give opinions when requested or spontaneously to the European institutions. But then there was this moment which is called in French literature le moment Delors, the moment of Jacques Delors, who was a very influential and strong historic president of the European Commission for more or less a decade. And Delors wanted to push the European economic integration, but he also wanted the Union, the European community, to show a social face and to be supported by the citizens, by the workers and the employers of the European Union. But there was one problem. There was one problem. In order to harmonize labor legislation, social legislation, Delors needed to have a consensus, unanimity among the member states. we are not yet dealing with the period, the era of the Maastricht Treaty, where for some issues of social law, qualified majority was sufficient. And the problem was that this consensus was going down the drain. It had existed in the 70s, okay, but there was no consensus anymore, especially once Margaret Thatcher was in power in the UK, United Kingdom, because she was not very keen on social legislation. She didn't want more social legislation. Now, Jacques Delors had a very intelligent idea. He said, when I can unite this or gather the employers' associations and the trade unions of Europe in a meeting, and when I can gain their support for some social reforms by asking them an opinion, if possible, a joint common opinion on my reforms, then I will be much stronger to convince these states to back me. Because if even employers agree with a certain position, why should a neoliberal government be against such a proposition or such a proposal? That was the reasoning. So you have Delors, who is weak from a political point of view, who wants to be empowered by this European social dialogue, and you also have another weak party, which is the trade union side, who cannot organize a pan-European strike to push, to exercise pressure, who are empowered in a way by a commission who wants to push a social agenda. That is the idea. This has amounted to the Val-Duchesse social dialogue, which is just a castle, or palazzo, you would say in Italian, palazzo outside Brussels, where these people met. And this was to some extent, this praxis was to some extent institutionalized and reinforced, corroborated by the Single European Act. First, a Single European Act, which says, okay, we promote the European social dialogue, and this European social dialogue can even amount to contractual relations. Contractual relations, that's fine, but of course the essence of the contractual relations is to push a kind of a regulation, but it's called contractual regulations. Then there is a step forward taken by the Maastricht Treaty, I would say rather 1992, which is interesting. The Maastricht Treaty is a complicated creature because it functions like this Russian matryoshkas, you know, this Russian puppets with puppets inside the puppets, etc. You have the Maastricht Treaty, which has reformed the Treaty on the European Economic Union, but which has also created a protocol annexed to the treaty, where all the member states together allow a social Europe to be built, with the United Kingdom not opting in. It's not that they opt out, but they decide not to opt in. And so you have another little Russian puppet. I'm sure they're cancelled by now, but I just used that image of the Matrushka, which is added, and that is the agreement among all the other member states except United Kingdom to go ahead with social Europe and to enlarge the competencies of the European Union in the field of social policy, to enact directives with qualified majority, but also, and this is important for us, subject to appeal to the social partners, allowing them to negotiate, allowing them to make an agreement, to conclude an agreement. And this is what I wanted to stress. By doing so, the employers might be more keen, more than ever, to conclude an agreement. Because if they don't conclude an agreement with the trade union side, there was this risk that the Commission would step in with a much more forceful, much more radical, much more progressive, if you want, social reform. And the employers' associations are hence bargaining under the shadow of the law. This was a wonderful expression which the late Brian Bukasson used to describe the phenomenon. And you see two weak parties, the Commission and the trade union side, but in this alchemistry, if the word exists, they are being reinforced. The Commission can always say, we are backed by a consensus among social partners, we can push the reform, and the trade unions can convince the employer side to conclude an agreement because they are bargaining under the shadow of the law, under the shadow of a potential intervention by the European Commission. Okay. Now, in 1997, the Amsterdam Treaty, always in the Netherlands, they must have had very bad dinners and lunches, okay, these heads of state. But in the Amsterdam Treaty, it was decided that this complicated system with the Matrushkas was abolished, and that this social policy title was fully integrated into the treaty, because the UK now wanted to join this process under Tony Blair, who in the beginning of his prime ministership pretended to be a socialist. Now, and then, of course, there is still a further evolution in the treaty, the Lisbon Treaty, which in a way made it abundantly clear that the Commission wanted to recognize the autonomy, the collective autonomy of the social partners, and which also made it abundantly clear that now the Parliament would be informed of this process. It's important to understand that if it works, if an agreement is concluded, that the Commission can implement that agreement by proposing a directive to be adopted by the Council of Europe. So you can see a mobilization of the directive, which formally, officially, is there to serve the will of the social partners, to implement the agreement which has been reached. Okay, that is what has happened. It's interesting to know, I think, that the Val-Duchesse spirit, this idea of bringing together the employers and the workers, has had even an impact on the drafting of the treaty. So this title, what has now become the title on social policy, which was in fact the agreement on social policy, and next to the protocol, was actually written not by the Commission, not by the member states. It was written by the social partners at European level who presented this piece to the member states to be approved of. So you can see that this European social dialogue has not just generated directives in the past, but has also had an influence on the drafting of the treaty, so had a constitutional impact. Now it's time to talk about the famous Italian scholar of Catania. Once upon a time, in the end of the 90s, was writing a PhD thesis at the European Institute of Florence. Very nice institutions in the hills surrounding Florence. And this person is called Antonio Lo Faro, and he was writing a PhD thesis under the supervision of Brian Bercuson. Remember, the first professor ever to be appointed at that European University Institute teaching EU labor law. Okay, and I had the pleasure to work, of course, with Brian Bercuson. So, and I already explained that he created this nice expression, collective bargaining under the shadow of law. Now, what were the findings of Antonio Lo Faro at the end of the 90s? So he's an Italian. He's much influenced by, obviously, it's much influenced by the way in which Italians look to collective bargaining, look to diritto sindacale, and he looks at this new phenomena from his Italian perspective, of course. And for an Italian, of course, collective bargaining is in essence about autonomia collettiva. Autonomia collettiva is a crucial concept. Being developed by Gino Giugni, but I could be wrong, but I don't think I'm wrong. And from an Italian perspective, you can only have a system of collective bargaining which is received, which is relevant for the state, if you have a set of fundamental workers' rights. Once I am speaking about during this course, freedom of association, right to collective bargaining, right to strike. And for an Italian standard, it is even extremely important because it's extremely important because you don't have a statutory framework. So these fundamental rights are extremely important to give some legal effects to collective agreements. And what Lo Faro has to conclude in his research is that, in fact, there is no recognition in the end of, at the end of the 90s, at EU level, general principles of EU law, neither of the freedom of association, neither of the right to collective bargaining, neither of the right to strike. And he's perfectly right to say that. In the meantime, things have changed, okay? These rights, due to the Charter of Fundamental Rights, have been recognized at EU level. But what Lo Faro challenges is the narrative, okay? The narrative of Jacques Delors saying, we will back the social dialogue. We will use directives, okay, to implement agreements. Because according to Lo Faro, it's not the Commission, it's not the EU institutions which are backing the social dialogue, it's the other way around. It's the social partners which are being instrumentalized, which are being used in order to overcome a paralysis, okay, a deadlock of a legislative process. And it then produces this wonderful thesis, which is published under the title Funzioni e finzioni della contrattazione collettiva comunitaria. You hear the music, funzioni, finzioni, it sounds like an opera lyrico, and then it was translated into English and the music stops. There's nothing musical about this title, Reality and Myth of Collective Bargaining. Nothing musical about it, but it's the same book. Okay. Now, it's very interesting, of course, because in France, this model was in a way copied. Huh? We have indeed in the French labor code an obligation for the government, if they push social legislation, statutory law, to appeal to the social partners, to allow the social partners also to come up with an agreement which can then be endorsed by legislation. Of course, in the meantime, we should say that collective autonomy, autonomia collettiva, has been reinforced. The notion of autonomy is now entered into the constitutional provisions dealing with the European social dialogue. And on top of that, the social partners themselves at EU level have decided to come up with a program, a kind of a Stalinistic program for years ahead. They fix the subjects of their social dialogue. In the Delors years, and in the immediate aftermath of the Delors years, the social partners adopted a more passive position. They waited until the Commission came up with a proposal which they envisaged, forcing the Commission, obviously, to consult social partners. Now, the social partners take a more proactive attitude. And you can see here this new provision, okay, new provision of the treaty where that notion of autonomy is being used. Unfortunately, autonomy is linked to an obligation to respect, where I would say that autonomy, if you really want to promote the role of social partners, if you want to promote the right to collective bargaining, which is an obligation of the Charter, then obviously autonomy would also trigger, in my view, an obligation for the Commission to intervene, not just to refrain from interfering, but also to push, facilitate, empower. Now, I now show you this historical visions, which you see that very first part, Article 155.1, which dates back to the Single European Act, okay, and the Maastricht Treaty, which was still blurry. The idea was that a dialogue could lead to contractual relations, including agreements. And then there is the idea, of course, in I'm looking for other points here. There is the idea that disagreements can be concluded, which are concluded, can be implemented in two ways. Huh? Two ways. There are two avenues of implementation. The first avenue are procedures and practices specific to management and labor and the member states. Is the autonomous avenue. You have an agreement and it is implemented by means of an agreement, collective agreement at EU level will be implemented by means of a collective agreement at national level. And then there is the second avenue, which is in fact, in practice, a directive which will be adopted, obviously, on a proposal from the Commission. And when it deals with a subject matter which requires unanimity, such a decision, read directive, will be adopted with unanimity if it is a subject matter where a qualified majority is required. It can be done with a qualified majority. Okay. Now there is also a thing which is called implementational bargaining. And this is about directives, the field of social policy, which might be directives implementing a collective agreement, or which might be directives in their own right, if the social dialogue fails, but which need to be implemented. And the question arose whether such an implementation should be based always upon a statutory law, or whether it could be an implementation through collective agreements at national level. In a way, this mirrors this first avenue, autonomous avenue of implementation, if there is an agreement. The answer is yes, this is possible. The EU treaty allows states to have recourse to their system of collective bargaining to implement directives. But there are caveats. Indeed, there is always the responsibility of the state to ensure that the results which need to be met by that directive are actually met. So the idea is that at the end of the game, you have rules which are as effective, as binding, which have the coverage intended by the directive. And this means that the collective agreement as such might not be sufficient. Member states should do something to ensure that this collective agreement is binding, that it covers all the workers, all the employers intended by the directive. In this respect, of course, in the past, well, Belgium was to some extent considered to be a good pupil for once, because in Belgium, collective agreements cover the entire private sector. Collective agreements are binding erga omnes if they are indeed flanked by a royal decree. But Italy has had in the past some problems because the agreements, the collective agreements in Italy as such are not binding erga omnes, with the exception perhaps of wages, but this is not relevant because that is the point. The EU is not competent as such to deal with wages, or definitely not to set wages. For this reason, the UK, okay, in the past, now it's not relevant anymore, had serious problems implementing directives through collective agreements. Was never envisaged because the legal status of a British collective agreement is even worse than that of an Italian collective agreement because it's a gentleman's agreement. There is no animus contrahendae obligatione, as we say. Now, I wanted to draw your attention also to that tricky notion which is being used in the treaties, in the treaty on the functioning of the European Union, social partner. That is the traditional translation in the non-English language versions of management and labor. So it's Partners sociali, Partners sociaux, Sozialpartner in Deutsch, and so weiter. And the question is, who are these social partners? How can we identify them? Now, pay attention. Pay attention, because we should distinguish the question, who are the social partners, for the sake of the consultation by the Commission. And the Commission is envisaging a proposal, a social reform, and the social partners which are effectively bargaining around the bargaining table and which might then conclude a collective agreement. Now, the Commission has clarified which organizations of employers and employees it considers to be social partners, and which it therefore is obliged to consult. And if they would not consult, there might be a problem. I mean, with the validity, obviously, of the directive. And then you have the social, so you have, in this respect, you have criteria developed by the Commission to identify the social partners for the sake of consultation. And then you have the social partners for the sake of bargaining, but these people, these persons, these actors are identified on the basis of a very subjective criterion, that is mutual recognition. Okay, mutual recognition. Now, to give an idea of what the Commission intends by social partners, I could say that the Commission wants to recognize as social partners only cross-industry or even sectoral organizations which are established at European level. And by doing so, the Commission is actually nudging these national employers associations, these national trade unions, to federate, to constitute a bargaining partner fit for purpose. And then there is something interesting. In order for these federations of trade unions to be recognized, or of employers associations, it's important that they consist of organizations which themselves are considered to be representative at national level. So the representativity of the European structure is based upon the representativity at national level, and not the other way around. Not the other way around. You're not representative at national level as Confindustria because you're a member of Business Europe. Business Europe is representative at EU level because it has among its members Confindustria. Do you understand the point? There should also be, and this is all based upon communications of the Commission, a capacity of these organizations to negotiate agreements. This means most probably that the European Trade Union Confederation can only be consulted if it can prove to have a mandate of its members to negotiate, in the end, to conclude a collective agreement. And then there is the idea that these European trade unions, European employers associations, should have adequate structures, okay, to ensure effective participation in the consultation process. Now, what is interesting here is that the Commission is not requiring, contrary to, in my view, what the Italian Constitution suggests, that these social partners have a democratic structure. It is not saying that they need to have corporate personality or something like that. It is not suggesting, apparently, that they prove that they unite or organize together the majority of the employers or the majority of the employees. Now, I hope you're still there, you're still following me. It's a rich dish. I want to look at the heart. I want to understand what this European social dialogue, which was instituted, with the Maastricht Treaty, because then there was really an obligation for the Commission to consult social partners, allowing them to conclude agreements. I want to understand what it has produced ever since. And I will communicate to you a paper, a small paper, which I've written for the Oxford University Press Encyclopedia of EU Labor Law. I will give you the draft because I'm unable to, in fact, to have access to that online encyclopedia. Never understood how it worked. And you see that there is a first decade. We call it the golden era of the European social dialogue, which has produced an agreement implemented by means of a directive on parental leave and a directive in the end on part-time work and fixed time work, fixed term work. And this is a glorious decade where you see a Commission pushing, nudging, where you have an external heteronomous, heteronomous start, which is then amounting to an agreement which will be implemented in a heteronomous way. So the second avenue, of implementation. You have an external authority envisaging social reform, asking social partners to negotiate. They conclude an agreement under the shadow of that law, and it is implemented by means of a directive. So it is heteronomous in the genesis, and it is heteronomous in the outcome. And it's dealing with, to some extent, issues of flexibility of the work organization, flexibility, derogating, if you want, from the standard contract, the standard contract, full-time and work for an indefinite period. And then we have something which is problematic. We have, I don't know whether I have this momento. Thing is going wrong here. But I wanted to say that you have a period of deadlock where the Commission is not pushing social partners anymore to make agreements, and where social partners in a way start to negotiate themselves, and where in fact they come to agreements, but these agreements are not sent to the Commission anymore to be implemented by means of a directive. So you have at the start an autonomous moment with the social partners fixing their own agenda, concluding an agreement which will not be sent to the Commission and which needs to be implemented by means of national collective agreements. So instead of having heteronymous genesis, heteronymous implementation, you have autonomous genesis, autonomous implementation. And then you also have something which is extremely problematic and a little bit more hybrid, because you have the Commission in this famous EPSU agreement, the Agreement on Information and Consultation in the public sector. You have the Commission asking social partners to make an agreement, so heteronymous genesis, social partners concluding an agreement, asking the Commission to implement it by the directive, and the Commission refuses, and this is a hybrid situation. Heteronymous genesis, in the end, because the Commission doesn't want to do anything, probably a autonomous avenue of implementation. Okay. It's important to know that at the sectoral level, you also have had collective bargaining, which in a first period has also amounted to directives, but they are on very specific issues, usually of working time, in sectors where working time is such a complicated subject that it could not be covered by the general directive on working time. And this was successful. It shows that in this field, the situation is so tricky, so complicated, that only the people on the field are able to come up with an arrangement. Okay. So when I was speaking about this autonomous genesis, autonomous implementation, I was referring to these framework agreements which I have listed here, and which in fact are dealing with new ways of working, telework, or which are dealing with the psychosocial risks, or with the issues of harassment and violence. So you can see that the European social dialogue follows what is trendy. I'm not saying that in a bad way, but what is apparently sensitive or what is taking place in society. But this has not amounted to directives, okay? Because the point is that in this era, the Commission under Barroso was not pushing legislation. It was very reluctant. It had another philosophy of what the EU was about. They were against too much red tape, okay? They were actually considering that the EU should not take care of little niceties, although these little niceties are in fact much more important than one might think. And we also had, I think, an alarming evolution in recent years with these other autonomous agreements dealing with inclusive labor markets, active aging. Why do I dislike these agreements? Because these agreements, they are not dealing with employment relations. They are not dealing with rights and obligations of employers and employees. They are really addressed to public authorities, suggesting these public authorities to engage in politics and the labor market. But this is like pushing us back into the era of the Val Duchesse, where social partners, in a way, agreed about policies which had to be undertaken by the EU institutions, or in this case, by national institutions. So this is not a subject matter for collective agreements as we know them from our national experiences. Now, the question is, so you see an evolution, in social dialogue, where, in fact, fewer and fewer directives are directives which implement agreements. Nowadays, most of the directives are adopted because the European social dialogue apparently is not able to come up with agreements, does not end into agreements. Although the times of Barroso are finished, I think you can see a commission which is genuinely trying to adopt social reforms, which is adopting directives on minimum wages, on transparent working conditions, which has reformed also major issues of the posting of workers. But I want to come up with this heteronomous avenue, this implementation of agreements, if they are concluded, by means of a directive. The provisions say decision, but in practice, the Commission has always opted for a proposal of a directive. Now, the Commission can only act if it is being asked on the basis of a joint request of all signatory parties. Now, there are some huge questions, and the reason why there are so many questions is that there is no statutory framework, okay, for the implementation of these agreements. You don't have a law on collective agreements, a directive or a regulation on collective agreements. You just have these very broad constitutional provisions, which, however, have worked in the past, and which do not, contrary to perhaps Italy, insist on an elaboration of a statutory framework to implement agreements. Now, first question, which could be asked, is whether there is an obligation for the Commission to act. Is there an obligation for the Commission to act? And if I read, I'm trying to go back to my provision, which says agreements concluded at union level shall be implemented. Brian Bercuson always shouted when he was reading this phrase, agreements concluded at union level shall be implemented. At first sight, this seems to suggest that there is an obligation if the Commission is indeed confronted with a joint request to implement such an agreement. But we will deal probably, I don't know, in the afternoon or so, with a the case, which is the EPSU case, to see whether indeed there is such an obligation. And I would say that unfortunately, the Court of Justice has said that there is no obligation for the Commission to implement an agreement, albeit there is a joint request to do so. Another question, if the Commission would adopt a proposal of directive, which still needs to be, of course, adopted by the Council, is whether the Commission, at least, has the freedom to alter substance of the agreement. And the Commission has pledged a vow that it will never change the text which was agreed upon by the social partners. And I think this is positive. Could wonder whether this also is true of the Council, but okay. Because an agreement is a trade-off between management and labor, and it would be extremely problematic if the Commission would change some parts, leave out some provisions, add other provisions, because the agreement is, of course, a very subtle compromise, a very subtle equilibrium. And it would, in fact, not be very wise of the Commission to change it, because their attitude of not changing it, in fact, allows these agreements to be concluded in the first place. Now, the question is what the Commission can do. The Commission, of course, should check, and has also pledged to do that, should check the legality of the text of the agreement. It should check whether it has to refuse it, has to reject it, because the text, for example, deals with subjects which do not fall within the EU competence. Suppose that the EU social partners would fix a minimum wage, nominative, saying the minimum wage on an hourly basis is, I don't know, 10 euros. Or the minimum wage on a monthly basis is 1,500 euros. Just an example. I think that in such a scenario, the Commission could not just propose to implement such a text, because this is outside EU competences. Wages in such an explicit way are excluded from EU competences. The Commission might also, in the name of the legality check, refuse to, and should do that, to envisage a proposal of and to propose a proposal of directive when the people at the bargaining table are not sufficiently representative in view of the subjects involved. But the big issue, and it will be addressed this afternoon, I think, dealing with the EPSO case, the big issue is, of course, whether the EU Commission can reject a proposal on the basis of an appropriateness test, what we call in decent French, and I think the expression is more clear, a judgment surrounding the opportunité, not the legality, but the opportunité of the text, the political desirability of the proposal. Obviously, this is an attitude which is not very respectful of the whole idea of collective autonomy, which is based upon an idea of horizontal subsidiarity, that when people are dealing with subject matters which are immediately relevant for them, rules which are only applicable to them, that they should know better what is in their interest than an external political authority, especially if two parties with very different interests are able to find common understanding. But unfortunately, okay, we will see that under the EPSU judgment, the Court of Justice considered that there was a margin, okay, for the Commission to reject proposals on the basis of the appropriateness of the text. So they can apparently exercise an appropriateness check. You could say, is there a role for actors in the legislative process, considering that this is a legislative process, but this is the thesis of Lofaro. Lofaro says the social partners are instrumentalized in order to overcome a legislative deadlock. So in the end, you have a legislative act. Well, the other bodies which in the legislative process are usually consulted, like the European and Social Committee, which also has representatives of management and labor and other NGOs, will not be consulted in the scenario of a directive implementing an agreement. Neither is the European Parliament consulted, neither has the European Parliament co-decisional powers. You might find this shocking that the Parliament is being bypassed. Well, I'm happy it is being bypassed, because if it would not be bypassed, you might have the risk that the representatives of the people, by means of the trade union, think A, and that the representatives of the people, by means of the Parliament, think B. And I think this would be extremely detrimental to the credibility of the trade unions and to the credibility of the European Parliament, because it would create a doubt, okay, about the representativity of both the trade unions and the social partners. Okay, now the question is, and I'm still digging into this hypothesis of an agreement concluded, implemented by a directive, which was the scenario of the first decade in the 90s. The question is, what is the relation now between the agreement, the original agreement, and the directive implementing it? Now, you can adopt two narratives. In the first narrative, which is what the texts are suggesting, the texts of the treaty, the Commission, the Council are there to help to implement the agreement. You could say that if the agreement disappears because it expires. Now, these agreements are not included for a fixed term, so they do not expire, but you could imagine that Business Europe ends the agreement. Why not? Unilateral termination is a normal thing. The question is, what would be the fate directive? If the directive is there to implement an agreement which disappears, you could say that the directive has no object anymore. And then you would need to say that when the agreement expires, the directive automatically expires, or when the directive, when the agreement was concluded for an indefinite period and that one of the parties terminates it, that there would perhaps be an obligation for the Commission to withdraw the directive or to ask for the withdrawal of the directive. But this is completely blurry. So this is not regulated by this very synthetic provisions in the treaty. So it's an enigma. You could also follow the thesis of Antonio Lofaro, who says, well, anyhow, these directives are not there to serve the social partners. It's the other way around. It is to overcome a legislative deadlock. And since the social partners play an ancillary role, they are the servants of the legislature, the legislature should not be bothered at all about the fate, the pre-existing agreement. So, my friends, I don't have the answer to the question. Okay? This might be a nice subject, I don't know, for future research. But then there is a subsequent question, and it's not about the relation between the two instruments, agreement, directive, it's about the relationship between the actors, okay? Social partners on the one hand, and the EU institutions. In the very first agreement on parental leave, it was provided that in the case of a dispute surrounding the directive, the social partners should be consulted. They should be consulted in order to give an interpretation, you might call it perhaps an authentic interpretation of the text implemented by means of a directive. Practice should know that such a directive consists of an annex, which is just the text of the agreement, verbatim, and a supplementary text, the formal directive, which just refers in a way, which just incorporates the agreement into the EU legal order. Now, in practice, this does not work. Practice, if there is a big dispute, for example, before the Court of Justice, the Commission does not consult social partners to ask to them what was the meaning of your agreement. And I know this because this issue was raised once upon a time by wonderful judgment, in a wonderful case, which is the Khat case. It's a case which always moves me to tears because it's about twins, and I'm part of a twin. Fortunately, not an identical twin. And Khatse was a mother of twins, Greek twins. She had given birth to them. And in case of a twin, it's two successive births based upon one pregnancy. Okay. She took her parental leave. And after a while, she came back to the employer and she said, I want to take my parental leave. And the employer said, but you already had your parental leave. And she said, yes, but you have to calculate this parental leave, not in function of the pregnancy, which is unique, but in function of the births of the children. And I had two twins, so I gave birth twice. So I want another parental leave. And then, of course, the Commission asked, scusi, but did you, it's a bit complicated, did you consult the social partners? Do you know what they intended? And in a very intelligent way, the Commission said, well, we don't have time. We did not have time to do that because this was indeed, in such a scenario, in this preliminary reference, a urgency. There was an urgency. There was a necessity to get this done and to get this dispute finished before the children would be too old, because you have to take the parental leave not when they are 25, you have to take it when they are still young. So the Commission said we didn't have time, but in practice the Commission never asks the social partners what they meant. And this, of course, evidences or highlights a big problem in the judiciary system. That is that social partners, although they are in a way institutional actors, they nearly are legislators, they have no access to court proceedings. They cannot intervene in a procedure which is about the interpretation of a directive based directly upon their agreement. And I think because the commission, the court would say, well, you don't have a direct and personal interest, basta. I think this is debatable because there is now the idea that the union, this is new in the Lisbon Treaty, should promote the role of the social partners. And the union is not just the Commission, it is also the Court of Justice. So I think that on the basis of that provision, there is an obligation for the court to accept interventions by the trade unions. This is an issue of freedom of association. France, because in a famous French case before the Strasbourg court, the Strasbourg court, I think it's Martelly versus France, or Adef Dromil versus France, the Strasbourg court some years ago said the freedom of association also generates a right for trade unions to intervene, to have access to the courts. And the freedom of association is part of the EU legal order. It is enshrined in the Charter of Fundamental Rights, and it should have the very same, at least meaning, as the one which is there in the European Convention on Human Rights. Okay. Then I think this will be my last, but nearly last slide. You have the autonomous avenue. Remember that in the treaty, it is said that agreements are implemented or in an autonomous way by practices of social partners in the member states, and that this historically was not used in the first decade of the social dialogue, but was used in the subsequent decades of the European social dialogue. Now the question is, how does this work in practice? And there are two possible interpretations. The first interpretation is that this is an automatic process, and then an agreement automatically gets the status of a collective agreement under national law. That therefore this autonomous avenue is based upon a self-executing mechanism. And this was a theory which was launched by my friend, a very good friend, nice guy, Olaf Deinert from Göttingen, which he defended in his PhD thesis, which he more or less, I think, defended in the same period as our friend Lofaro. But Olaf Deinert is the only person in the world to share this opinion. Although I must say that he has a lot of intelligent arguments, and in fact uses the concept of freedom of collective bargaining, collective autonomy, as the argument triggering such an obligation for member states to receive the European collective agreement in their system. Another colleague, Dagmar Schick, very much influenced by, I think, Italian writings about ordinamento intersindacale, the writings of Gino Giugni, said that it would be up to the social partners at European level to create a system, perhaps in connection with the national social partners, to guarantee this reception of the European collective agreement in their national system as a national collective agreement. What usually happens is that, because such a general framework has not been elaborated by the European social partners, what usually happens is that, of course, at national level, the national trade unions and employers associations affiliated quite often to, of course, Business Europe and the European Trade Union Confederation will try to implement this European collective agreement by concluding ad hoc a collective agreement according to their national system. Now, then the question is, of course, what happens? Suppose that there is such an agreement and it is implemented by the social partners. Can then the European Commission do something? They have not requested the Commission to do anything. That is clear. There was not a joint request. But does this mean that the Commission has no legislative powers anymore? This is not very clear. I think if the Commission wants to do something, they should still consult national European partners. Now, I would end this chat for today, and then I will give you the floor because it was a very long lesson, with pointing out the existence of another phenomenon of collective bargaining, which had no link at all with this legislative process, and which is a phenomenon of collective bargaining which is not technically occurring at EU level. It is just occurring at the transnational level of some European multinationals. Because what we have seen over the past decade is that a lot of agreements have been concluded at the level of multinational companies in Europe. And it's interesting because it shows that there is no direct relation between legal frameworks to empower, to facilitate, to nudge, and what is actually taking place in what you would call the ordinamento intersindacale, in what you could call a kind of legal order made up by social partners. Because a lot of agreements have been concluded at this transnational level, where they are not being concluded anymore, or much less at the big European level. And this phenomenon raises a lot of questions, because we have no legal framework to deal with complicated legal questions, like the question, which are the bargaining partners? Should we accept that the European Works Council, which in a way is based upon a directive, have the powers to conclude collective agreements at transnational level? Now you might say, yes, but why not? Well, I will say why not. Because this would amount to a situation where you empower implicitly Works Council to the detriment of trade unions. And that, my friends, is against the case law of the ILO in matters of freedom of association. You have other complicated questions, like what about the levels of collective bargaining? What if these collective agreements conflicts between the collective agreements at national level and transnational level? You could say, well, why shouldn't we give precedence to the national level, to the transnational level? Transnational, it's like international, it's logical that it has primacy. Yes, it's not that evident. It's not that evident because in a lot of countries, we have the idea that the branch level should have primacy over the company level. And this transnational level is a company level. And anyhow, if you apply Santo Romano to this scheme, you can just say, we have a clash between legal orders here. We might have a clash between legal orders and different views upon hierarchy, especially if the European legal order has no framework at all to deal with the question. The question is, of course, can an ordinary employee invoke such a transnational agreement against his employer, part of the group? We don't know, because there is no legal framework, I mean, dealing with the effects of this framework agreements, transnational framework agreements. We will see what will happen. It would be nice if, of course, the concluding parties in the agreement would create mechanisms for monitoring, arbitration, etc. That is a solution. It would be great if member states, on the basis of common general principles, would give some binding effect to these agreements, because they are agreements, pacta sunt servanda. What the Commission has abandoned is the idea to push framework on transnational company agreements, and it's now just pushing the conclusion of the agreements, but not pushing the framework which solves the disputes emerging from them. Dear friends, I give you, because I have been talking much too long, but it's a big issue here, I would like to give you the floor and ask you whether you have questions. You can obviously put questions in the conversation. You can also ask questions if you're very timid in Italian, and then I will translate it into English. You have the floor. I still see number of participants. 10.
And Philip also in French, in
yes, French,
Flemish,
Dutch.
and so Dutch, and so on. So we have multiple languages to choose from. So
yeah, indeed. So don't hesitate. It was a huge dish. So I will provide some more materials.
No, the presentation was really challenging and very dense of information, concept, and so I imagine that there is that the students could be shy to pose you some questions, but I invited them really to do so because it's you have dealt with a lot of very significant subjects and issues, so I'm sure that there will be something to ask you. From my side, I ask you this, which is, did you use these two acronyms, ESC and EP? Because we are not really very used to those acronyms. So
yeah.
Please, if you could please tell us what they stand for.
ESC in this so I think it's on one of the slides, no? EP was European Parliament, I think, and ESC, this is really it's a mistake. I meant the Economic and Social Committee. And it's a bit confusing because it could also mean European Social Charter. But in this context,
yes,
it means Economic Social Committee, which is usually, in fact, consulted when directives are adopted in the field of social policy. And I must say it's a very interesting committee because it has no power at all. And since it has no power at all, these people always try to come up with a joint opinion. And it's very interesting to see how employers associations, NGOs, and trade unions come up with an opinion which is shared by all of them. And they do so because it's the only way to have some influence at all. And there is a lot of experience in this committee. I once participated to one as an expert to one of these meetings. These are usually senior staff members of employers associations with a lot of experience and a lot of expertise. And it's also, and sometimes also very sound legal knowledge. And it's always interesting to read these opinions.
Yes, indeed. Everybody caught this problem on this side, on this slide about the borders of the obligation for the Commission to implement an European collective agreement. Do you need any further explanation about the exact content of this obligation,
I will deal with it this afternoon. Because this afternoon we are going to analyze the case.
The case. Okay, fine.
And then, yeah.
Okay, fine. So it's better to postpone the explanation in the afternoon.
Yeah.
Okay, fine. Any other questions?
I still
no question.
I
give the suggestion to my students of my course to re-listen to this lesson, to this presentation. I will upload the recording on Virtuale, and it is also present in the chat of this room, this virtual room. So please re-listen to Philip.
There's a question.
Fine. Please, Ben. You are. Yes, please, Ben.
I'm sorry. I tried it the whole time, but it seems like my software wasn't working.
Okay. Thank you, Ben.
I got one question on the main thesis of Lo-Faro. I did not quite understand if this is a debate that has been solved and there's one definite answer, or is it just Lo-Faro's opinion and the opposite opinion, and it's an sort of ongoing debate and you have to side with either one?
Yeah. It's a good question. I think that the book of Lo-Faro, which you can read so in Italian and in English, is of course not a purely doctrinal positive law analysis of the European social dialogue. It is more like a theoretical reflection, which is also in a way multidisciplinary. And to some extent, I think what Lo writes is very accurate, but I think that things have changed afterwards. I think that the legal framework applicable to the EU social dialogue has changed. So it does not mean that history has proved him to be wrong. He was wrong. He was right, I think, in his analysis when he was writing the book. But I think the legal framework has evolved. Although we have now a very strange situation. I will come up with that in the afternoon. That Lo says that these directives, in essence, are legislation, okay? Because what the social partners do is to prepare and to facilitate a legislative process. And now we have a situation where the Court of Justice of the European Union, I will come to that in the afternoon, at least the General Court, that part of the Court of Justice says, this is not legislation. This directive is not a legislative act. Very strange. Huh? I would say yes. What is the discussion closed? The discussion has, of course, no immediate legal consequences because it's also a theoretical, multidisciplinary reflection of Lo Faro. But what the court is actually doing, in a way, although the General Court says this is not legislation, what the court is actually saying corroborates, in essence, what Lo Faro explained, because Lo Faro is criticizing the fact that the EU institutions do not respect collective autonomy, that the EU institutions, in a way, have too much control over the autonomy of the social partners. And everything, what we have seen is that the control of the EU institutions over the social dialogue has become stronger and stronger, that autonomy has become less and less, because they are now explicitly, the EU institutions reject on the basis of opportunity, appropriateness, the implementation of agreements, for example. That really is a lack of respect of the autonomy of social partners. So in a way, Lo Faro, if you interpret it in that way, was right. Although technically speaking, we now have a recognition of what he was looking for: freedom of association, right to take collective action, and right to collective bargaining. But this has not created, this idea of autonomia collettiva has not created an attitude of respect of the EU institutions towards the precepts of collective autonomy at European level. I hope, do you understand more or less what I'm trying to say? It's a bit complicated.
Yes, thank you for clarifying.
Yeah. Nice question.
Okay. Yes, very, very nice question. Okay, so we can end here if there are no other questions. Thanks again, Philip, and thanks to all the participants to this morning lesson, to this morning class. See you this afternoon at 3 p.m. Okay, bye to everybody.
Ciao ciao.
Ciao.
Arrivederci.